Well, thank you very much for coming today. Welcome to the Institute of Advanced Legal Studies. My name is Stychin, and I'm the director of the Institute. And tonight is a really special occasion in our Institute calendar. We welcome our Inns of Court visiting Judicial Fellow, who will be speaking this evening. I should say the fellowship is generously supported financially by the Inns of Court. It is a long-standing fellowship which allows a distinguished member of the judiciary from another country to visit our institute for an extended visit, a sabbatical visit, to engage in research and to present it to audiences here. It is a competitive process, and I can attest to the fact, as I chair the selection committee, is that the quality of applicants who are nominated by the Chief Justice in their jurisdiction is extremely high. And the committee each year makes a very, very difficult decision as to who the recipient will be each year. This year was no exception. We had distinguished applicants from around the world, but the unanimous view of the committee was that tonight's guest should be this year's Inns of Court visiting Judicial Fellow. So with that by way of introduction, it's an honor for me to be introducing tonight's distinguished guest, Justice Sir Dominic Adjei of the Ghana Court of Appeal and Justice of the African Court on Human and People's Rights. Justice Adjei is also one of the 9-member advisory committee of the International Criminal Court. His biography, which I am going to give, I'll have to be an abbreviated version of his biography because his accomplishments are wide-ranging, diverse, and incredibly impressive. Justice Adjei is a fellow of the Ghana Academy of Arts and Sciences. He is a graduate of the University of Ghana, Ghana School of Law. He was called to the Ghana Bar in 1993. Besides being a distinguished member of the bar, he is a distinguished academic. He holds Executive Master of Public Administration degree from the Ghana Institute of Management and Public Administration. He obtained his Masters of Law in Criminology and Criminal Justice from the University of London. So we're pleased to welcome back to the university. He also holds a Master of Judicial Studies from the Duke Law School in the United States. Justice Adjei is the acting director of the Judicial Training Institute of Ghana, having held the substantive office for a number of years. He's a former dean of the Faculty of Law of the Ghana Institute of Management and Public Administration, previously president of the Association of Magistrates and Judges, and the list goes on and on. He is the author of 6 law textbooks used by law faculty, schools, and members of the legal profession. And on a recent trip to Ghana, Justice Adjei generously gave me 2 of his books, which have a pride of place in my office on the top floor of this building. Justice Adjei was knighted by the Holy Father, Pope Benedict, into the Order of St. Gregory the Great in 2005. So without further ado, it's an honor and a privilege to welcome Mr. Justice Sir Dominic Adjei.
Thank you, Carl, for the kind words. Good evening. It's a pleasure to see all of you here. I know you are busy, but you sacrificed your time to be here, to be a party to this presentation. I thank you very much for coming. And it's an honor to be here. I'm going to discuss an interesting topic. Why an interesting topic? The reason is that we always talk about freedom, rights. How do they manifest in the day-to-day activities of man? So that is what we are going to discuss this evening. And the topic, as could be seen from the board, the right to information to promote transparency and accountability, and the right of protection provided by international and national laws within Ghanaian context. So for the abstracts, I believe most of you read it, so I'll proceed to the next aspects. I'm going to talk about the following thematic areas are to be addressed. The first one, I will introduce the topic. Then the next one, historical antecedents of freedom of expression in international law. I will also talk about recent instruments on the right to information in international law. Then obligation to comply with international law. The right to freedom of information on environmental protection. Legitimate grounds to restrict freedom of expression. Then I'll move on to the right to information in Ghana, historical perspective. Then protection of the right to information in Ghana's Fourth Republic. Positive effects, negative effects. Then the areas that have been exempted. Then the laws that provide exemptions and prescribe sanctions, that these have been exempted, therefore sanctions have been provided, and if you violate, you are dealt with in accordance with law. Then how do we get access to court? People talk about contempt. How are we going to deal with contempt when we are talking about freedom of expression? So after freedom of expression and contempt, then we talk about freedom of expression and journalism. Then I'll conclude. Thank you, I'm proceeding. The introduction, let me start with the introduction. Public institutions hold information acquired while performing official obligation in trust for the citizen. In the context of information access and this lecture, the phrase public institutions refers to institutions established by the Constitution and other laws, as well as private organizations and institutions that carry out duties or receive public funds. Let me explain it briefly. What I'm saying here is that when you talk about public office, you hold public office. It is not for you. You are holding it in trust. It is for the whole country. But you have been appointed to be an accountant, to be an engineer, to be CEO. It is not your personal thing. You are therefore accountable to the citizenry. Then in addition to that, what about private organizations who receive support from government? In Ghana, for instance, we have the private hospitals managed by the mission hospitals. We have the Catholic hospitals, Presbyterian hospitals, Anglican hospitals. Who pays compensation? It is government of Ghana who pays compensation. That is the staff. And therefore, they are also accountable. Even though in a sense it is private, they are accountable. As trustees and fiduciaries, public institutions have a duty to uphold the public confidence by being accountable, transparent, being honest to the public. This is especially true given that they receive public funding. However, there is no denying that authoritarian regimes and their agents conceal information in their possession to avoid being held responsible by the people they rule. In order to end the cycle of tyranny and guarantee the free flow of information from governments to citizens, declarations, treaties, agreements, and covenants have established freedom of expression as a fundamental right. When we say fundamental, inalienable, nobody can take it away from you. Further, many states have passed Right to Information Acts, which offer legal protection for anybody requesting information from public officials. So can you go to any establishment and tell them, I want ABCD and mandatory they should give? That is what we are going to discuss. The right to information is inextricably linked to freedom of expression. Freedom of expression can be exercised in numerous ways. It encompasses actions or inactions which have expressive content. Thus, the International Covenant on Civil and Political Rights, ICCPR, it is one of the conventions which almost every continent, almost every country has ratified, almost, apart from few ones, almost. Then the ICCPR provides that it may be expressed by a person, orally, in writing, in print, through acts, through any other forms of media of his choice. That is, if you are coming up with information, it can be in any mode. The phrase other forms of media of his choice encompasses communication made via satellite, the internet, DVDs, CD-ROMs, cables, and media players. So if I have information about you, I can send it to the internet, CD-ROM, in any mode. Nonetheless, the free flow of information, whether scientific, real, demonstrative, electronic, documentary, or digital, must be regulated. Information is a powerful tool because it has the capacity to affect other people's thoughts and behavior. Thus, regulation may be necessary for various reasons, including national security, public order, territorial integrity, public safety, protection of health or morals, respect for the rights or reputation of others, prevention of crime or disorder, and confidentiality of received information, as well as maintaining the impartiality and authority of the courts. If you have freedom to seek information, it doesn't mean that you have the right to go and publish false statements about somebody. Therefore, states must pass laws protecting the right to information, impose appropriate limitations, and establish procedures for accessing unrestricted information. Not all forms of expression are protected. The content and context of expression are relevant. Thus, let me talk about this case briefly. Texas versus Johnson, where somebody was annoyed in America and he bent the national flag. The federal court said that yes, majority of 5-4, they heard that yes, burning of the American flag was protected speech under the First Amendment to the U.S. Constitution and did not constitute an offense. Determining the boundaries of the right to information is a difficult issue, but this should not be an excuse for failing to enact a law that effectively protects it. Rather, it should be seen as a recognition of the growing complexity that dynamic cultures around the world face. We should not abandon the idea entirely. We should not throw the baby out with the bathwater. In this lecture, we will explore the international legal framework surrounding the right to information, taking into account the International Covenant on Civil and Political Rights, the European Convention, the African Charter, and the American Covenant. The focus will then shift to Right to Information Act 2019 in Ghana. Then we will assess its impact, how it is promoting accountability and transparency, and making the public accountable to the citizen. I'm now moving on to the historical antecedents. The historical antecedents of freedom of expression in international law. The history of the right to information could be traced to two instruments that were established after the Second World War to guarantee the free flow of information between the states and avert the outbreak of another war motivated by a shortage of information. The two instruments are the UN Resolution 59-1 of 1946 by the United Nations General Assembly and the Universal Declaration of Human Rights of 1948. I'm talking about the UN Resolution 59-1 of 1946. The purpose of Resolution 59 of 1946, adopted as freedom of information, FOI, was to grant individuals the freedom of expression to gather, communicate, and publish news without restriction. During the Second World War, we heard about Adolf Hitler trying to suppress information. So now they want people to have access to information. And this is the content of the resolution. I quote, "Freedom of information is a fundamental right, and it is the touchstone of all the freedoms to which the United Nations is consecrated. Freedom of information implies the right to gather, transmit, and publish news anywhere without fetters. As such, it is an essential factor in any serious effort to promote the peace and progress of the world," unquote. Now, if you look at it, it says that freedom of expression is free. There are no fetters, meaning you can go and say whatever you want to. But is that the world that you want to live in? Then the answer is no. The resolution seemingly provided for the right to information in absolute terms by stating that the right ought to operate without fetters. It appears that a person's freedom to obtain, gather, transmit, and publish opinions and other forms of expression through the media was unaffected by any limitations of any kind. However, the author submits that the word without fetters should be construed in a way that is compatible with the purpose of Resolution 59. The purpose was to make information available so that there wouldn't be any other war. If things are going on, expose them. So are we also saying that they have the right to incite wars, say words that will bring another third world war? It cannot happen that way. So in this phrase, without fetters, is construed strictly. It might lead to absurd inference that the resolution will defend the spread of information intended to spark a war. In reality, Resolution 59 was not an absolute right. Otherwise, it would have defeated the purpose for which it was passed. It cannot be used as a pretext to commit criminal offenses, disturb the world peace, violate public order, national security, damage reputation, commit criminal offenses. The resolution did not prevent nations from penalizing those who spread false information in an effort to ignite a new world war. Additionally, Resolution 59 did not purport to repeal the common law defamation right, which allowed a person whose reputation has been harmed without cause to pursue defamation claims and appropriate remedies, such as reparation and injunction. It is unlikely that a resolution from an organization like the United Nations will give an open license to violate another person's human rights or take any action that will endanger the state security or the public interest. Quite often, when we attend meetings by journalists, the emphasis is on the UN resolution and the Universal Declaration, because they will say that, oh, the two instruments are saying that we can publish without fetters, and therefore there is no need to restrict our publications. And lawyers are saying, no, you are giving wrong interpretation. Let's have a look at the United Nations Declarations of Human Rights. The second instrument, the Universal Declaration of Human Rights of 1948, is soft law. When we say soft law, it was made by then colonial masters in favor of their subordinates or in favor of their colonies. And the purpose was that it was not made as a law to bind anybody, but respect it. When we say a law is a soft law, the essence is that it is not binding on you, but you must respect it. So in the essence, it goes back to square one. Now, the Universal Declaration, the Article 19, which is germane to this topic, reads as follows, and I quote: "Everyone has the right to freedom of opinion and expression. This right includes the freedom to hold opinions without interference and to seek, receive, and impart information and ideas through any media and regardless of frontiers," unquote. So this one, if you read it literally, it means you can go and publish whatever you want to do, but we can live a world that permits anybody to go and defame people, to incite people at war, to commit crime and others. Although Article 19 of the Universal Declaration makes the right seem absolute, a holistic review of the Declaration reveals that the right is not unqualified. Rather, it is subject to other fundamental human rights provisions, particularly those provided in the Declaration. Article 30 of the Declaration is to the effect that no one exercises a right under it to destroy the rights and freedoms provided in it. That alone places fairness on the rights in the Declaration. Also, Article 1 of the Declaration provides that all persons are born free and equal in dignity and rights. Thus, it will not confer unfettered rights on persons not to respect the rights or reputation of others. Most jurisdictions, up until recently, considered certain publications to be intentional or careless act of defamation against other people. And they were therefore illegal. In Ghana, the Criminal Offences Act 1960 Act 29 had criminalized negligent and intentional libel prior to the passage of the Criminal Code Repeal of Criminal Libel and Seditious Law Amendment Act 2001, Axis 02. Those who violated it faced criminal sanctions, distinct from civil sanctions, which flow from the tort of defamation. In Nigeria, as at now, Section 373 of the Criminal Code deals with criminal defamation, where a publication is made against any person that is likely to injure his reputation by exposing him to hatred, contempt, ridicule, or to damage his profession or trade. It is a criminal offense. In South Africa, the Supreme Court of Appeal held in Poho against South Africa that criminal defamation forms part of the laws of South Africa and that the offense is committed when a person unlawfully and intentionally publishes a matter concerning another person with the aim of injuring his reputation. In that case, the court affirmed the conviction and sentence of 3 years imprisonment, suspension for 5 years, in addition to 3 years of correctional supervision for 22 of the 23 counts of criminal defamation. Whenever you give a lecture and you talk about South Africa and you mention the Supreme Court of Appeal, people think that you are wrong. You are not wrong. That is the hierarchy. From their high court, you appeal to the Supreme Court of Appeal. Unlike here in Ghana, where from the high court you go to the Court of Appeal, then you go to the Supreme Court. They are combined the two, the Supreme Court of Appeal. But they have Constitutional Court as an independent court. On 28 October 2020, just about 2.5 years ago, the Sierra Leone Parliament repealed criminal libel from its statute book, which had existed for over 55 years. The United Kingdom kept its common law crimes of criminal libel and seditious libel until they were abolished by the Coroner's and Justice Act 2009. The blasphemous libel in the UK was also abolished by the Criminal Justice and Immigration Act 2008. So it was all over. The above paragraphs confirm that states did not interpret the true instruments, international instrument, in absolute terms. And they are therefore curtailed. Let's look at the recent instruments on the right to information in international law. So here we are moving to international law. The International Covenant on Civil and Political Rights, which I said as ICCPR. Then we have the European Convention on Human Rights, ECHR. We have the American Convention on Human Rights, ACHR. Then the African Charter on Human and People's Rights, ACHPR, are the 4 international documents on the right to information that will be discussed under this subtopic. The above instruments confer rights on individuals to express an opinion and seek, receive, and publish information to deepen democracy with specific restrictions. According to its preamble, the ICCPR was created in keeping with the Universal Declaration of Human Rights, the United Nations Charter, and the rights derived from a person's inherent rights to dignity. The ICCPR was designed to safeguard civil and political rights. On December 16, 1966, the ICCPR became available for signature, ratification, and admission in accordance with General Assembly Resolution 2200A Roman numeral 21. Article 49 of the ICCPR provided that it was to come into force 3 months after 35th Instrument of Accession was submitted to the UN General Assembly. This happened on 23rd March 1976 and has been in existence since then. The freedom of expression and the right to hold beliefs without interference are governed by Article 19 of the ICCPR, and it provides as follows. 1. Everyone shall have the right to hold opinion without interference. 2. Everyone shall have the right to freedom of expression. This right shall include freedom to seek, receive, and impart information and ideas of all kinds, regardless of frontiers, either orally, in writing, or in print, in the form of art or through any other medium of his choice. 3. The exercise of rights provided for in paragraph 2 of this article carries with it special duties and responsibilities. It may therefore be subject to certain restrictions, but these restrictions shall only be set as provided by law and are necessary. A. For respect of the rights or reputation of others. B. For the protection of national security or public order, or for public health or morals, unquote. The covenant explicitly declares that the right to information is a fundamental human right. However, freedom of expression is subject to limitations that are necessary to respect others' rights or reputations, preserve public safety or order, or uphold public morality or health. So if you are publishing anything, you must have these things in mind. If you offend any one of them, you have violated the convention. One cannot use their right to freedom of expression as a cover to harm someone else's reputation or to engage in behavior that may be detrimental to morality, public health, or public safety. States are required to enact laws to cater for the restrictions mentioned in the covenants. The ICCPR makes a clear distinction between the right to freedom of expression, which is not an absolute right, and the right to hold opinions, which is an absolute and cannot be interfered with by member states. The right to freedom of expression relates to the dissemination of information. There are duties and responsibilities imposed on a person's right of freedom of expression, as it must be made within the limitations provided by the national laws of that person. So here we have international law. It has given you the parameters. Then you need to enact national laws to give effect to the restrictions provided by the international law. The right to hold opinion is an absolute right, not subject to interference by the state, as expressed in paragraph 1 of Article 19 of ICCPR. At common law, based on the principle established in R versus later, here we talk about, so what about if there is an information which should not be disclosed, but I managed to get it, what will be the effect? Can I use it? You can use it, but when it comes to the courtroom, that is where we talk about admissibility, inadmissibility. In the courtroom, the common law principle was that once you have information, irrespective of how it is obtained, once it is relevant, it could be used in court. But now we are changing it gradually. In Ghana, the position is now not settled. There is a recent case of Kubaji versus Asare and others. I know that Kubaji very well. Kubaji's case was that Kubaji was litigating with the Presbyterian Church in Ghana, Sunyani. Then he went to the pastor, said, "Pastor, I have brought an action against your church. You know that the land is for me." And the pastor said, "Yes, I know it's for you. Don't run my people." Then he recorded him. Then the pastor came to court to give evidence. He said, "It is not for me." He said, "Pastor, I came and recorded you. And he said it is for me. So now I'm using it against you." They traveled to the Supreme Court. But the Supreme Court held that under Article 18.2 of the Ghanaian Constitution, it has provided exceptions. And once this is a civil matter, it was inadmissible. So if it were a crime, morality, public order, it would have been admitted, irrespective of how it is obtained. And so now, even in UK, there are several decisions, R versus Ritam, R versus Sang, then Ritam, the House of Lords held in recent case of AG versus reference that even though the police should not have kept the accused DNA without his consent, it was relevant and should be admitted into evidence. They kept his DNA without his notice. And when they came to court, they wanted to use it. He said, no, you didn't tell me. You have surprised me, and you took it without my consent. But the court said, is it relevant? Is it your DNA? So once it is yours, if it for how it is obtained, it will be admissible and was admitted. Now, we are going to look at another instrument, the European Convention on Human Rights, ECHR, also guarantees the right to information and freedom of expression. The Convention carefully limits the right to information under Article 10 in recognition of the dire consequences of unfettered rights. These limitations are both for the benefit of the wider public, such as public safety and national security, and for individuals, including the protection of confidential information and the reputation of others. Now let's look at Section 10 of ECHR, what it says. I quote, 10.1. Everyone has the right to freedom of expression. This right shall include freedom to hold opinions and to receive and impart information and ideas without interference by public authority and regardless of frontiers. This article shall not prevent states from requiring the licensing of broadcasting, television, or cinema enterprises. 2. The exercise of these powers, the exercise of these freedoms, carries with it certain duties and responsibilities, and may be subject to set formalities, conditions, restrictions, or penalties as are prescribed by law and are necessary in a democratic society in the interest of national security, territorial integrity, public safety, for the prevention of disorder or crime, for the protection of health or morals, or for the protection of reputation or rights of others, for the prevention, the disclosure of information received in confidence, or for maintaining the authority or impartiality of the judiciary. So here, at a later stage, I will talk about the impartiality of the judiciary. That's why I will talk about contempt. So we use contempt to regulate freedom of expression. Otherwise, people will lose confidence in the courts. The ECHR considers the right to information and the right to hold opinions under freedom of expression and places limitations on both as are necessary in a democratic society and for the protection of reputation of others. The ECHR does not draw a distinction between the right to information and the right to hold opinions. Under the ICCPR, the right to hold opinion is unrestricted, but the right to hold information is restricted. But when it comes to ECHR, both of them have been restricted. Both are subject to restrictions by the member states within the parameters provided in paragraph 2 of Article 10. Article 10 of ECHR is more detailed than Article 19 of ICCPR, but both articles essentially state that exercising one's right to free speech entails certain duties and obligations. States are also required to clearly lay out any conditions or restrictions based on any of the aforementioned justifiable reasons in order to protect that right. So if you are a member of the European Commission and you are curtailing freedom of expression, then it must come within the parameters provided by Article 10. If you go outside it, you have violated the provision. In the case of Director of Prosecution versus Casirio, Lord Bennett C.D. discussed the relationship between freedom of expression and freedom of assembly and associations under Article 10 and 11 of the ECHR respectively, and held that both rights were qualified rights subject to the restrictions that must be imposed by law and necessary in democratic society, among other things, to protect others' reputations in the interest of national security, public order, and to maintain the authorities of the courts. So the authority of the court is always paramount. Effectively, the restriction of the right to information guaranteed under Article 10 of ECHR by a country will not necessarily constitute a breach of that country's obligation under the ECHR. Admittedly, Article 10 of ECHR employs vague language. How is one to determine if a restriction is placed where the restriction placed is necessary in a democratic society? So there's lack of clarity in Article 10.2. The task ultimately falls on the judicial authorities. That is the essence of the court. Whenever a provision is vague, unclear, ambiguous, it is the duty of the court to interpret, to make them sensible. The right to information is also provided under the American Convention on Human Rights. This convention, which came into force on 18 July 1978, is often referred to as Pact of San Jose. Now, the American one. One thing about it is that it tells you that if you violate it, you shall be punished. But if you look at the ICCPR, it provides that these are the restrictions. ECHR provides restrictions, but the ACHR provides sanctions. We are going to have a look at it soon. Now, let's look at Article 13 of the American one. Everyone has the right to freedom of thought and expression. This right includes freedom to seek, receive, and impart information and ideas of all kinds, regardless of frontiers, either orally or in writing, in print, in the form of art, or through any other medium of choice. 2. The exercise of the right provided for in the foregoing paragraph shall not be subject to prior censorship, but shall be subject to subsequent imposition of liability, which shall be expressly established by law to the extent necessary to ensure A. Respect for the rights or reputation of others. B. The protection of national security, public order, public health, or public morals. 1. Any propaganda for war and any advocacy of national, racial, or religious hatred that constitute an incitement to lawless violence or any other similar action against any person or group of persons on any grounds, including those of race, color, religion, language, or national origin, shall be considered as offenses punishable by law. So the American one, when you enact, you go ahead to create a criminal offense. Let's look at the African Charter on Human and People's Rights. It's a human rights instrument for the member states of the African Union. There are 54 countries in Africa, and all of them have signed. To enforce strict adherence to the Charter's provisions, the African Commission on Human and People's Rights and the African Court on Human and People's Rights have been established. And when we talk about the European Court, we have the European Court on Human Rights at Strasbourg in France. And the African one is in Arusha, Tanzania. And the American one is in San Jose. So we have 3 continental human rights courts. And all of them are regulated by their respective covenants or charters. Like the other documents mentioned above, the Charter, the African Charter, does not declare freedom of expression to be a fundamental. The boundaries of the restrictions were not specified, but the member states are required to implement laws to control freedom of expression in their individual nations. Ironically, all of the Charter signatory nations also belong to the ICCPR, and that's subject to its limitations. All the 54 African countries are members of the ICCPR. So where there are gaps, you use that of the ICCPR, because they are all international instruments. Article 9 of the Charter, which is on right to information, provides as follows. Quote, every individual shall have the right to receive information. B, every individual shall have the right to express and disseminate his opinions within the law, unquote. That means you have the right, but it must be within your local laws. So if you go in excess of your local law, you commit an offense, and you'll be dealt with in accordance with your own laws. Fortunately, most African nations are signatories to the ICCPR. They are prohibited from arbitrarily limiting freedom of expression. A review of the International Human Rights Instrument reveals that whilst they each seek to guarantee the freedom of expression and the right to information, the scope of those rights and the permissible limitations are not identical. For example, because Ghana is a signatory to ICCPR and ACPHR, it may be more prudent to catch claims against Ghana for the breach of the right to information in terms of ICCPR instead of ACHPR. You know, when you violate a right and it is before any of the continental court, If you appear before the African Court of Human Rights, you can see that this one violates Article so and so of the African Charter. Then you go ahead to say that this one also violates Article so and so of ICCPR. Because you are a signatory, once you are a signatory, then the African Court has the right to determine. It is noteworthy that international human rights courts and tribunals are not limited only to instruments which establish them, but rather the other instruments which the states have executed. Obligation to comply with international law. This is a bit technical, but very interesting. We have international law, we have local laws. When a law is made by a country, we call them national or local laws. But the international covenants that I've been talking about, that's what we call the international instruments or the international law. When they are in conflict, how do you resolve them? That is what I'm going to address now. The domestic law of each country determines the circumstances under which treaties, conventions, and agreements executed by them are binding on domestic play. There are two categories of countries when it comes to execution of treaties, conventions, and agreements. Now here, we have two types of countries. We have the monists and we have the dualists. When we say a country is monist, meaning immediately you execute an international law, it is binding on you in your own country. Like countries such as Belgium, France, Germany, Netherlands, once they sign a treaty, it is binding on them. But UK, Ghana, and others, we belong to the dualists. When you go and you sign, the president will sign. It will bind us at the international level, but we must domesticate it in our law before it will become sources of law in our domestic jurisdiction. So Ghana belongs to the dualist country. If Ghana signs an international instrument and Ghana violates, or Ghana signs, you cannot come to our court to use them unless it is domesticated by Parliament. But you know, the Americans, they do the hybrid. They have intentionally categorized their laws into two: self-executing treaties and non-self-executing treaties. That's one. When it comes to argument and you want to bind them, they will tell you this one, it is not self-executing treaties. You require other activities to activate them, and therefore it will not form part of our local laws. So if you look at the sources of law in Ghana, Article 11, it doesn't talk about international law because it is not part of our law unless it is domesticated. And the domestication may take two forms. Made by Parliament. So let's look at Article 75. The President may execute or cause to be executed treaties, agreements, or conventions in the name of Ghana. A treaty, agreement, or convention executed by or under the authority of the President shall be subject to ratification by an act of Parliament or a resolution of Parliament supported by votes of more than one half of all the members of Parliament. So now the question is, then why do the dualist countries waste their time on international law? We are going to discuss that one. The ICCPR and ACHPR, which Ghana duly ratified in international level, are only binding on Ghana in international law because they have not been ratified by Ghana's Parliament. A Ghanaian who believes that one or both of the two international agreements have been violated may file a complaint with the ECOWAS Community Court, where there is no requirement that local remedies have been exhausted. You know, if you are going to ECOWAS court, it is a bit freer that a country has violated an international law within the ECOWAS sub-region. You just go and file. But if you are coming to the African court, you must satisfy us that you have exhausted all the local remedies up to the apex court. And those violations have not been addressed. That is why you are coming to the African Court on Human and People's Rights. So let's look at the irony here. In Ghana, as I read Article 75 not long ago, some of you who may not know about Ghana, Ghana is regulated by a constitution. And the constitution was made in 1992. And it came into force on 7th of January 1993. And the constitution says that the constitution is the supreme law. All other bodies and laws in Ghana are under the constitution. That is why in Ghana, when Parliament makes law, Supreme Court may strike it down as unconstitutional because it violates the constitution. Unlike here where they may say it may be incompatible, Ghana Supreme Court will strike it out as unconstitutional. The president may take a decision. Somebody may challenge it in the Supreme Court that it is affront to a provision in the Supreme Court. The Supreme Court will strike it out as unconstitutional. Now, even though the law says that we must domesticate before we can use, we have a provision on human rights. That is chapter 5 of the Constitution of Ghana, from articles 12 to 33. It is on fundamental human rights. Now, the 33.5, the one ending the whole provision on human rights, says that, yes, even though Ghana is a dualist country, you must come and domesticate international laws to make them national laws. When it comes to human rights provisions, you don't need domestication. Article 33.5 of the Constitution reads as follows: the rights, duties, declarations, and guarantees related to fundamental human rights specifically mentioned in this chapter shall not be regarded as excluding others not specifically mentioned, which are considered to be inherent in a democracy and intended to secure the dignity of man. So the two conditions are that the first one, you must establish that that human right is inherent in democracy, and two, it is intended to secure the freedom of dignity of man. You don't need domestication. So here, that is why we discuss all the international instruments, where there is a provision on freedom of expression, and it is fundamental human rights. You can borrow it from the European Commission on Human Rights. You can borrow it from the American Covenant. You can borrow it because it is a human right, and it is intended to promote the dignity of man. So that is the advantage that we have under our Constitution. So the law itself says go and domesticate. But where is human right elsewhere? No, you can use it. The right to freedom of information on environmental protection. Now, issue of environment has become a very critical thing. In Ghana, we are talking about environmental pollution, degradation, sea pollution, everything. So what do we do? Now, there is this right to freedom of information on environmental law. It is very important that we rebreathe laws on environment. As a result of that, the United Nations Conference on Environment and Development, UNCED, also known as the Rio Declaration because of Brazil, on environmental development, or the F Summit, it was held in 1992 to discuss environmental protection. It was attended by 170 heads of state and 170 representatives from states and international, continental, and regional bodies. All the countries in Africa attended. Then after that, the principal thing says that the resolution taken at the summit, which is on right to access to information on environmental matters to safeguard and protect a clean and healthy environment for the living and unborn generation, provide as follows. So this is the communique. Environmental issues are best handled with the participation of all concerned citizens at the relevant level. At the national level, each individual shall have appropriate access to information concerning the environment that is held by the public authorities, including information on hazardous materials, activities. So all these things, the law says that, yes, when any country which attended, when they go back, they were required to ensure that whenever a person demands for freedom of information or access to information and it's on environment, they shall make it available to that person because it is to protect the living and the unborn generation. Then, so here, then in 1989, the Adjei Convention on access to information, that one was determined by only the Europeans, but we are using them because it is a fundamental human rights issue. Initially, we thought that environmental law belonged to different angles, but now most of them have become human rights. So it recited all the laws at Rio and concluded that the grounds for refusal requests for information on environmental matters may include the public authority does not possess the information. The request is manifestly unreasonable or too broadly formulated. The information has been exempt from disclosure under national law due to being in draft form or concerning international communications of public authorities, or disclosure will harm the security of the state or confidentiality. Apart from these grounds, you cannot deny someone access to information. So all these things, fortunately, we may argue them under sections 5 to 7 of the Right to Information Act of Ghana. So now, I want to take us to another interesting topic: legitimate grounds to restrict freedom of expression. Now, we have freedom of expression. If you restrict them, those available, which are unrestricted, that's where you have a right to seek for. Now, the legitimate grounds to restrict freedom of expression. We have discussed all of them at the international levels, the international instruments. We discussed all of them, so I'll mention only one or two. In exercising the power to restrict the freedom of expression, which includes the right to freedom, states must satisfy the three-part test to ensure that the restriction is lawful. The first one is that each part of the test must be satisfied. It will not be sufficient if only one or two of the tests has been satisfied. The first part of the test requires the restrictions are legitimate. The restrictions that you are imposing on freedom of expression. The first consideration is that it must be legitimate. Legitimate from any of the international instruments that we have discussed. This means that restrictions must be prescribed in an enactment, relevant, clear, accessible, and free from excessive official discretionary powers vested in the state. The second test is that the restriction must pursue a legitimate aim. I am restricting it. What is the purpose? To pursue a legitimate aim. Then the third one, the aims are those restrictions listed as exceptions in international instruments. Then the final test deals with whether the restriction is necessary to meet the social needs of the state. State must use these means which are proportional to the objective for which the rights are restricted. That means if you are restricting based on any of the international instruments, you must conform with the three-part test. Is it legitimate, pursuing legitimate cause? Then, is it proportional to the needs of the people? The right to information in Ghana, a historical perspective. So now we are in Ghana. Ghana attained independence on 6th of March 1957. Then, after 6th of March 1957, this law was passed, the Deportation Act of 1957. If you said something which was offensive to the president or whatever, and you were perceived not to be a Ghanaian, you'll be deported. So, several people were deported, including politicians, who had some of their parents from Ghana, others from Nigeria, all of them were deported. They were crying, we are Ghanaians, but they were deported. Then there was also another law, which we call the Preventive Detention Act. The law provided that if somebody's act is prejudicial to the security of the state, then the person will be detained in any of the prison or police custody up to 5 years without access to court. And some people, including Bafo, Akutu, Rui Akutu, and others, all of them were detained for 5 years without assigning reason. People thought that it was signed by Dr. Nkrumah. No, it was signed by the Governor General, not Dr. Nkrumah. So he came and took advantage of it. So the same law, if you're a member of Parliament and you were detained under that law, you were disqualified and you lost your seat. The 1960 Constitution brought Article 13, which everybody was happy, that it was a Bill of Rights. But when it was challenged, the Supreme Court then said that it wasn't a Bill of Rights. It is just a moral duty, like the coroner's oath, like the coronation oath, which is taken by the king. And as a result of that, the state had the power to detain other people. In 1964, there was a referendum which brought into being Act 244. When that referendum was passed, all the judges became timid. The reason was that the president had the power to remove judges of the superior court at any time for reasons that appear to the president to be sufficient cause. What do you mean by sufficient cause? No definition. Then there was a coup d'etat. The government was overthrown. The soldiers came. When the soldiers came, they also passed a law to detain people up to 28 days without access to court. And they may even extend it. Then in 1969, we had the second Republican Constitution, which was similar to the Westminster Constitution. Unfortunately, in about 2.5 years, there was a coup d'etat, it was overthrown. There was a provision on freedom of expression, but it couldn't materialize into act. The government was overthrown. Then the soldiers came. You know, whenever the soldiers come, you know, they share information, they arrest people. So it continued until we had the 1992 Constitution, Article 21F, which talks about freedom of expression. A person shall have the right to information subject to such qualifications and laws as are necessary in democratic society. So here, this is the basis for which Ghana has come out with is the Right to Information Act. It is derived from this constitutional provision. So the Right to Information Act was passed in 2019, Act 989, and it came into force on 21st of May 2019. And it is to provide information and exemptions on legitimate grounds. So if you look at it, it has provided several grounds, but it does not apply to information held by national archives. Go there, libraries, go and research, museums, go and look for them, when the public has access to seek for information. The right to information was established as a fundamental human right to give the people of Ghana the inherent power to hold their elected president accountable. The government as trustees for the people of Ghana and they as beneficiaries have the right to know everything within the public sector unless matters are lawfully exempt from disclosure on legitimate grounds. So here we talk about what we can do and what we cannot do. Now, we talk about the hospitals, private hospitals. So what do you mean by information? The information has been defined broadly to include recorded matter, material of whatever form, medium that is under the control, possession or custody of a public institution, irrespective of how it was made or produced by a public institution. And in the case of a private body, it must relate to performance of public function. And if you look at the long title, it speaks volume. And in UK, the long title to the law is not part of the law. It is just against you to the law. But in Ghana, the long title and preamble form part of the law. So here it forms part of the law. Now, let's look at the restrictions. First, it says that the Act requires public institutions, including departments or agencies under them, to publish manuals containing current, accurate, and authentic information held by them. Every 12 months, you must revise for us to know the information that you have. So if I want to know something about the Korebu Teaching Hospital or University of Ghana, I will just file my application to them. I want this information. It has come to my notice. You have bought 20 cars. Where did you buy them? The cost, mode of procurement, and I'm entitled to all this information. And they must publish them in their manuals. And the manuals are to be revised every 12 months. And if you want to receive, you apply for, then you are giving, you pay for it, but it is a token. It is not much, just a token. Now, if somebody uses an application, it must be responded within 14 days. If the person refuses that it is within bills exempted, then you repeat it to the chief executive of that institution. If he refuses it, then the next forum is you either go to the High Court for judicial review or you go to the Right to Information Commission. They have powers to deal with them. So if you go to the High Court, I've discussed everything. If you are dissatisfied, you can appeal to the Court of Appeal and finally to the Supreme Court. Let's look at the instances where direct access is allowed. When the information has already been made public, when the request for information is time sensitive, when the head of the organization is information officer, all these things you cannot deny. Then when the application is submitted, it must be granted. It has positive effects and it has negative effects. The negative effects, the government power to intercept communication. One thing is that if government is to disclose, then you are also required to disclose what you have in your custody. And that one, they have extended it into the arena of crime. I will discuss them very soon. So when we talk about the right to information, all the restrictions provided for are within the international law, and we can see that it conforms. Section 14, which partly deals with information that is exempt from disclosure, and it is likely to constitute contempt of quasi-judicial body. This one, Ghana, what we know is contempt of court, contempt of parliament, contempt of district assembly. We don't have contempt of quasi-judicial body, but this law has introduced it. So now, it will be up to the courts to interpret what do we mean by the contempt of quasi-judicial body. So the ministers, let's look at some of the areas exempted by law. The instances where information has been exempted include information prepared for submission to the president or vice president for consideration, or containing information regarding advice, deliberation, minutes, opinions, consultations, or recommendations that are likely to prejudice national security or undermine the deliberative process. Information held by cabinet, its subcommittees, all of them. Then cabinet has authority to grant access. Then information containing law enforcement and public safety. These exemptions are not absolute. Most of them are not absolute. So when you put in an application, you tell them, I'm coming under this provision, it is not absolute. The other areas that exempt from disclosure under the law include information that affects security of the nation, very important, economic and other interests, economic information of third parties, unless it has already been disclosed or made publicly available, information regarding tax, unless the person it concerns agrees to its disclosure, information regarding the internal workings of public institutions, including opinions, advice, giving recommendations, or the deliberative process that may be disclosed if it contains statistical or factual data. So these are the areas that have been exempted. But Article 135 of the Constitution says that where a document is of public nature and it is prejudicial to the security of the state or injurious to public interest, you must go to the Supreme Court for Supreme Court to determine whether it should be disclosed or not. Enactments that provide for exemptions and sanctions. The State Secret Act provides that where a person obtains information, records or publishes any state secrets intended to be useful to a foreign power, either directly or indirectly, or makes any sketch or model intended to be used by a foreign power, commits an offense. The Right to Information Act has criminalized the willful disclosure of exempt information. Where the law has been exempted and you go and disclose, you commit an offense. And if you are tried and convicted to a term of not less than 6 months, the minimum sentence is 6 months and the maximum is 3. Then the Cyber Security Act has criminalized the publication of pornographic images of a child, any child, where it is pornographic, and you publish, you disclose, you commit an offense. Or indecent image of a child, or you use computer, internet bulletin, local bulletin, or any device capable of storing data or transmission, or publish or store information relating to a child for sex abuse. If you disclose any one of them, you'll be tried. Then a person who is convicted of the offense of aiding and abetting, it is punishable. Some of them 10 years, some of them 5, minimum of 5 years. A person who is convicted of the offense of cyber stalking a child shall be liable to a term of imprisonment of not less than 5 years and not more than 15 years. So these are the things that. Then sextortion, sexual extortion. You have an affair with somebody, or you have, if you don't do this, I'll do this. If you don't, I have this information about you. If you feel I'm going to disclose, we call it sextortion, sexual extortion. You know, most men are now scared. And if you do that and you are convicted, the minimum sentence is 5 years and the maximum sentence is 25 years. Without an option of a fine. Then the person may also sue you or do other things. The state's power to access information from the people. Now, we are holding the state accountable. The state must also hold us accountable. Otherwise, people will be storing materials that will be inimical to the security of the state. Now, the government also requires information from individuals in public interest. As a result, the government has enacted several laws which empower the government to obtain information from individuals, including the Constitution, criminal offences, the economic and organized, banks and specialized, all these laws, the government has the power. So if it is about the banks and specialized deposit-taking institutions, they can go to any bank and seize any material. If it is Criminal Offences Act, they may come to you and say that it has come to our notice that you have done A, B, C, D, you are under search, you are coming to search your room. The Narcotics Control Commission, where you have chat with somebody on phone and you discuss narcotics, they can tap your communication and use it against you. Then the Cyber Security Act gives authority to investigate officers investigating. This law is very, very serious and important one. The Cyber Security Act 2020, Act 1038, gives authority to investigative officers investigating an offense under the Act to make an ex parte application to the High Court in camera for production order to obtain the subscriber information relating to. So here, what it means is that if you are in Ghana, you use the telecommunications, either Mobitel, mobile phone, Airtel, or whatever. The law is that they must store every communication that passes through that link for minimum of 12 months. So whenever the president or the country requires that information to use against you, they go to court with an ex parte order. When the application is granted, then they send it to the communication, either it is Mobitel, Airtel, or whatever, and they are bound to make them available to the investigative body within 3 days. And you know, the funny thing is that one of them, which I heard, it was about they were planning to deal in narcotics. So when the order was made, and you know, it is not encrypted, where it is in message form, they will decrypt it. And here we talk about the normal voice that we use. They will give everything to you within 1 year. So if you talk on phone, be careful about the things that you say, because they are recorded for minimum of 5 years in Ghana. And it's just a matter going to court with an ex parte order to get them. Then Section 71 of the Narcotic Control Commission Act empowers the Director General of the Commission, subject to Article 18 of the Constitution, to intercept communications and parcels likely to contain information or substances that may assist in narcotic offense. Then Sections 10, 11, and 12 of Criminal Offences and Other Procedure Act 1960 empowers the police to arrest and search for information by search warrant executed in accordance with law. Then we have other bodies such as the Special Prosecutor, Economic and Organized Crime. All of them have the power to intercept with communications, to use them against you in criminal trials. Then the bank one, the Banks and Specialized Deposit Taking Act 2016 Act 98 empowers the person authorized by the Bank of Ghana to examine the books, records, minutes books, files, and personnel of financial institutions under the Act as part of the supervisory powers of Bank of Ghana over all other banks in the country. So that's one of them. Access to court and the power of contempt. Everybody must have free access to the court. But we are talking about having confidence in the court. That is public order. And therefore, the courts have been empowered to ensure that the dignities of the court are always preserved and protected. And we have basically in Ghana, we have two types of court. We have the lower courts, then we have the superior courts. The lower courts, we have the circuit court, we have the district court, we have the juvenile court, we have the chieftaincy tribunals. They do not have power to commit for contempt unto themselves. And you have the superior courts, Supreme Court, Court of Appeal, High Court, and the regional tribunal. They have the power to commit unto themselves contempt. Now, there are very interesting revelations when it comes to the power of contempt in Ghana. We have civil contempt. Civil contempt means disobedience to an order of a court. That one is very simple. But the most serious one is the criminal contempt. It consists of contempt committed in facie curia, that is at the face of the court. And when we say at the face of the court, meaning the court heard it, the court saw it, and now, during the 2012 election petition in Ghana, where the late Sir John insulted one of the judges, that is Atuguba, you know, the courts were not there. But Supreme Court said that we were listening to the national news and we saw you insulting the judge, and that one, it is considered to be committed in the face of the court. And they pleaded for mercy. Then there was this lawyer who was also a journalist, Mensah. Then he published a serious matter about one of the judges of the Supreme Court, that the judge has adopted his decision. He serialized it on 3 occasions. It was about the former president, that former Prime Minister of Ghana, Dr. Adjei. Then the first publication was that Justice Aban is a liar. Then he says that Justice Aban's scandal takes a dramatic turn. Then the third one, Aban puts the integrity of the bench on the line. Here, the question is, it could be true that Aban said it, but we have the right to say it. You know, when you talk about contempt, truth is immaterial because we are protecting the dignity of the court. Unlike defamation, where truth constitutes defense, justification. But when it is contempt, you are undermining the court. Then he was convicted for publishing materials which were scandalous, abusive, and calculated to bring the administration of justice into disrepute. So freedom of expression is restricted when it comes to contempt matters, as the law has established that the truth or falsehood of publication is not a defense, and the court will not take into account if it is established that the publication violates any of the restrictions imposed by law. Now, let's go back to the European Commission on Human Rights. It says that when you are limiting freedom of expression, these are the things that you must take into account. And part is that which restricts freedom of expression as prescribed by law and is necessary in a democratic society to maintain the authority and impartiality of the judiciary. So it is one of the restrictions permissible to ensure that people do not undermine the competencies of the courts. So here, the European Court of Human Rights have decided several cases under these headings. Particularly this case, where this case is an interesting case. The municipal court in Zagreb, in Croatia, determined a matter. Then somebody who was dissatisfied, the party who lost, filed an appeal to the Zagreb County Court, and he insulted the judge in the notice of appeal. Then he argued that it is my fundamental human right to argue. But the European Court of Human Rights convicted him for contempt because it amounted to undermining the administration of justice. I'm winding up very soon. Freedom of expression in journalism. Another tricky area. Journalists are of the opinion that they can see everything. But the law says you cannot see everything. And they will go back to Universal Declaration and say that no fetters. The law says that it's absolute. Now, do we allow journalists to tread on different paths while all others go on different paths? And the question is no. I quite remember last year I attended a training session in Kenya. I presented a paper, and one of the journalists said that if you are a journalist, you can insult a judge, you can insult a court, and there is no, and they don't have any vested right to deal with you. And I said, you are wrong. Go and read the law and understand. So if you look at the ICCPR, ECHR, ECPR, and ACPR, they do not exempt journalists from the restriction of freedom of expression. They are like us, like any other body. So where it has been criminalized, and you go and publish, you will be dealt with. Now, the United Nations Education, Scientific and Cultural Organization, UNESCO, is protecting journalists. And everybody is sad that journalists are being killed for disclosing wrongdoings in countries. But here, the emphasis is not on wrongdoing. The emphasis is on violating the rules on non-disclosure. So Ghana, these laws, we have them because we are common law jurisdiction. All the common law jurisdictions, we have contempt because we must ensure that the court is robust and impartial and must be respected by all. Now, let me spend just some few minutes on what we mean by closed court and open court. Closed court means that when we are hearing some matters, it must be held in chambers, or we should not give access to people. Or even if journalists may come, we allow them with only pen and paper or pencil. then they write something to go and publish. But quite often, we see that because they may write things that they did not hear properly, they may come out with distorted facts. And therefore, people are advocating for open court. Then the open court, should the open court be absolute? No. It must be operated within the restrictions. So where it is about matrimonial matters, where it is about matrimonial, divorce and others. So here, let's have a look at the ICCPR. It forbids the press and the public from attending cases on specified grounds. All persons shall be equal before the courts and tribunals. In determination of any criminal charge against him or his rights and obligations in a suit at law, everyone shall be entitled to a fair and public hearing by a competent, independent, and impartial tribunal established by law. The press and the public may be excluded from all or part of the trial for reasons of morals, public order, or national security in a democratic society, or when the interest of the private lives of the parties so requires, or to the extent strictly necessary in the opinion of the court in special circumstances where publicity would prejudice the interest of justice by any judgment rendered in criminal case or a suit at law shall be made public except where the interest of juvenile persons otherwise requires or the proceedings concern matrimonial disputes or the guardianship of children. And the funny thing is that in Nigeria, matrimonial cases are held in public. And it is provided by their rules. So here, when we talk about open court, we should allow generally free access to court, but they should not disturb the court. They should come ahead of court sitting. We give them ample time. Put your equipment here, motionless. Then they record. They can go and show to the people. Because if you ask everybody to come to the courtroom, how many? The court cannot take 200 people. Meanwhile, everybody may be interested. When it comes to presidential election dispute, everybody would like to see, so that in future they may tell their children that I saw it. And therefore, we are saying that it is a fundamental human right to promote open court. Open court in unrestricted areas. Where it is restricted, you cannot. Where it is unrestricted, then we should give them free access. In the paper, I've discussed several authorities. The South African court said that audiovisual broadcasting is part of freedom of expression. Then the South African Supreme Court of Appeal has issued practice direction that it is free, provided it is unrestricted. Then the United Kingdom also endorses open courts, including audiovisual broadcasting of court proceedings, as a right to freedom of expression. Here, we are talking about unrestricted areas. Lord Deco defined open justice as a fundamental right inherent in common law and narrow exceptions. In criminal cases, all evidence communicated to the court is made public. So these are the things that then we come to the Children's Act in Ghana. It says that if you publish any information that may lead to identification of a child in a matter before a family tribunal, except with the permission of the family tribunal, you commit an offense. And if you commit, you are dealt with, whether you are a journalist or whoever. It is immaterial. Then journalists should be prohibited from attending open hearings in cases where their admission will violate Constitution or ICCPR provisions or in-camera proceedings. There is a controversy over whether cases said in camera can be published in law reports for public consumption. It is a dicey issue. People, when we are hearing matrimonial matters, it is said in camera. But when judgment is delivered, then the Council for Law Reporting will go and publish it. And everybody will read what happened. Because you are restricting people. But at the end of the day, you are going to make it available to the people. And now we are saying that we should stop. We are saying we should stop. What we must do is that go and report only the legal issues and leave the facts. Because you are going to embarrass people. So conclusion. Freedom of expression is a vital tool used to deepen democracy. It finds expression in several international human rights instruments and domestic laws around the world. It inspires hope of a world with fewer wars, corruption, environmental degradation through transparency and accountability. And it helps us to enforce international law. Then the 19th Constitution of Ghana and the Adjei Act provides sufficient legal support for the enjoyment and enforcement of the right to information. Nonetheless, the full enjoyment of this right depends on the attitudes of public institutions and the courts to ensure that an effective response is given to is given to steps taken in the exercise of right to information. Thank you very much.